Let's talk about divorce in Trinidad and Tobago. Before we begin though, there's a couple things you should know. I am not a lawyer. This is not legal advice. This episode is sponsored by potbake.com. If you're interested in good local books, please visit their website. You can order books and have them delivered straight to your doorstep. Divorce. It's hard on everyone. You, your family, and your kids. It's hard on your future ex and your outside thing. In 2013, 8,117 couples said I do. The same year, 2,465 couples said and formalized their divorce. Using those figures, that means 1 in every 3 marriages in Trinidad and Tobago ends in divorce. In Trinidad, there's one ground for divorce, that the marriage has irretrievably broken down, meaning that there's no room for reconciliation. Your marriage, like the roads in Labrie, cannot be fixed. A divorce can be contested or uncontested. This is Archie. How much times I had to tell you that is the wrong Archie? This is Chief Justice Archie. Remember him. A divorce is granted in 2 stages. The court first issues something called a decree nisi, which is a document that says the court doesn't see why you can't divorce. At a later stage, the court grants a decree absolute, which means you're free to remarry. And that's good news. It may be bad news for some people. Say, for example, there's a divorcee who now has to find another reason to give the outside man or outside woman why they can't get married. In the time between the decree nisi and the decree absolute, any party who objects to the divorce can come forward with those objections. Can you imagine if someone objects to your divorce? You know what's the first thing I'd tell them?
Why the you didn't object to my marriage?
In 2010, 2,000 divorces were granted. Opening the 2017-2018 law term, Chief Justice Archie said, "Oh shucks man, how much times I had to tell you that is the wrong Archie? Pop the right picture now man." Opening the 2017-2018 law term, Chief Justice Archie announced that 2,878 petitions were filed. The year before, the courts issued 2,110 decree nisi. 94% of people getting divorced got their nisi within a year. Remember, the nisi is the first milestone in getting divorced. It's followed by the decree absolute. According to the judiciary's website, you could get a divorce in 4 months. Assuming, of course, everything runs smoothly. Do you know what that means? That means that in Trinidad and Tobago, you could get a divorce faster than you could get your passport. If you go online and search for divorce in Trinidad, you'll notice a couple things. People are searching for information about the divorce process, about the rights of women, about alimony, or according to some people, all your money, and about unreasonable behavior. What exactly is unreasonable behavior? You'll also notice something that should embarrass the courts of Trinidad and Tobago. The details on their website aren't straightforward. Why is it so hard for organizations to document and communicate how processes work? On the court's website, not court's website, boy, the courts of Trinidad and Tobago. If you're looking for documents related to divorce and you go on the court's website, you have to download a 6 megabyte PDF document to find out how the process works. The court's website also includes other resources you will need if you're representing yourself. These files, which you will have to edit, are available as PDF documents. If you search online for divorce in Trinidad, the US Embassy's website has clearer instructions. So here's an idea that will make everyone's life a lot easier. The courts should create fillable PDF forms so people can download the forms, fill them out on their computer, print them, and sign them. In Trinidad, divorcing someone is very easy, especially if there are no disagreements when it comes to money, assets, and the kids, and no outside man or no outside woman is involved. One spouse must request a divorce. That spouse is known as the petitioner. The other spouse in legal jargon is called the respondent. In the petitioner's circle, the respondent is known as the bitch or the jackass. In Trinidad and Tobago, there is one ground for divorce, that your marriage has broken down irretrievably. Meaning that like cocaine and marijuana in evidence rooms across Trinidad and Tobago, it cannot be retrieved. There are 5 ways of proving that a marriage is irretrievable. The jackass has committed adultery, and the petitioner finds it intolerable to live with the respondent. The bitch has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. The jackass deserted me. We've been living apart for more than 2 years with agreement. Or we've been living apart for more than 5 years without agreement. I have no idea where he lives. I cannot even find the jackass on Facebook. To apply for a divorce, you do not need a lawyer, but it is in your best interest that you have one. Remember, if you decide to represent yourself, you could find resources on the judiciary's website. Hopefully by the time you're getting divorced, the courts courts have created fillable forms. To start proceedings, the average lawyer in Trinidad and Tobago charges $5,000. Of course, the price increases depending on the case's complexity, assets, kids, alimony, which makes you wonder if it's in your best interest or your lawyer's best interest that you have a lawyer. Your lawyer will prepare the necessary documents and speak for you in court. If you cannot afford a lawyer, you can apply for legal aid through the Legal Aid Advisory Board, on the condition that you make less than $7,000 a year. But if you make less than $7,000 and you're thinking about a divorce, please, I advise you, think twice, because bro, she didn't marry you for the money. The Hugo Wooden Law School also has a legal aid clinic, which, like Mount Hope's Dental School, gives students the chance to practice on you for a small fee. There aren't any restrictions for filing for divorce. Either you or your spouse must have lived in Trinidad for at least 1 year, which, truth be told, may have contributed to your divorce. If you're having problems, leave. Get Out. Those are two excellent movies. Watch them together, then leave. So, how do you apply for a divorce in Trinidad and Tobago? Usually you must be married for at least 1 year. Otherwise it just looks bad, especially if you had a big expensive wedding. But if you can show that you've suffered extreme hardship, you can apply for permission on the grounds of unreasonable behavior, which can include but isn't limited to domestic abuse, verbal abuse, shouting or belittling, drunkenness, excessive or lack of sex. So if he's living in the rum shop more than he's living inside of you, you could apply for a divorce. And here's some great news. Behavior isn't confined to the petitioner. It is what affects the marriage. That includes the respondent's behavior to your mother. Can't take that mother-in-law. You need to file a petition at the family court asking the court to end your marriage. This document outlines how you wish to prove that the marriage is irretrievable. Along with the petition, you must file supporting documents such as a copy of your marriage certificate, details about other cases in any court about your marriage, the children, or matrimonial property. If you have kids under the age of 18 who are still attending school, you must prepare a document called the Statement of Arrangements for the Children. Money for school, money for books, money for mommy. It costs $50 to file a petition. Each supporting document costs $5. You also have to pay a service fee, which varies based on where your spouse lives and how far the official who will ultimately serve the petition on your spouse has to travel. If you live in South or Tobago, you can file your petition at the family court in Port of Spain. Because South, like Tobago, has no family court and no good nightclubs. South people and Tobagonians can also file at sub-registries in South Trinidad or Tobago, the Supreme Court on Harris Promenade, and the Supreme Court in Scarborough, Tobago. If your petition claims that your spouse has committed adultery and you find it intolerable to live with him or her, you will have to name the Horner man or the Horner woman. The person you name is also served. So if you named Little Jack Horner is going to get a copy of the petition and supporting documents. Can you imagine being in the same room with that person? The petitioner must provide hard proof. For example, admission of the respondent, existence of a child, they were caught in the act, inference from circumstantial evidence, whether it's pictures, videos, phone records. Please note the following. Petitions that try to prove that a marriage has broken down irretrievably because of adultery are usually contested. This is a long, dirty road. When you're going to file your petition, remember to work with cash. Organizations like Licensing Office and Family Court only accept cash. Trinidad is a real place. Once you file your petition, you'll get a date of hearing. Approximately 8 weeks from the date of filing, the respondent must be served personally. He or she has 8 days to defend the petition. The respondent may want to make changes with respect to matrimonial property or the kids. If the jackass decides to contest the petition, he or she has an additional 20 days to file an answer. Along with the petition, the respondent receives 2 forms. An acknowledgement of service form, which he or she must complete and file within 8 days. A notice of proceedings, instructions and details about the matter. Let's jump to the first day of the hearing. If your spouse does not contest the divorce, you, the petitioner, present your evidence. The judge will state if he or she is convinced the marriage has broken down irretrievably. The judge issues a decree nisi. Remember, a decree nisi is not the end of your marriage. You still have to wait at least 6 weeks. Let's talk about settlement. Who gets the house, the car, the kids? It isn't a winner-takes-all scenario. The court isn't there to rule in favor of the woman. The court prefers if a couple can work out these details on their own. They may recommend mediation. In dividing property, the court's aim is to place the parties as close as possible to the financial position they would have been in if the marriage had not broken down. The court considers the income, the ability to earn, property and other financial resources which each party has or is likely to have in the near future, their age and how long they were married. Custody, care and control is not automatically granted to the mother. The court looks at which parent may be better placed to provide for the child. The court prefers joint custody with care and control going to the parent with whom the child will reside. However, if one party exhibits unreasonable behavior, the courts can deny access to that parent. Once a judge is satisfied with the arrangements, you will receive your final document, the decree absolute. Game over. If, however, your spouse contests the divorce and you all can't see eye to eye on anything, buckle up and enjoy the ride. Red Wall News. It's better than blues.